Happy Sunday, everyone. Welcome to It's All Legal 2. We're about to kick off another episode of Sunday Sessions, and I am your host, Janine Hovell-Cox. And I hope everyone has had a blessed day today. And I know that football season has already started back up, and I am so happy about that because football season is my favorite time of the year. So I hope your teams won today if you are football fans, and for those who know me, know that I am a diehard Steelers fan, so we don't play until tomorrow night. But anyway, we have a really great show for you guys today. We're going to have with us attorney Darryl E. Scott, who is an intellectual property attorney, and he is going to talk to us about protecting our brands. I know I had a Sunday Sessions a few weeks ago where we talked about social media and marketing, and I had questions come up regarding copyrights and trademarks, so I couldn't think of a better person to come on and talk to us about protecting our brand. So I see that Darryl is in the room, and we are just going to bring him in. Give us a second. Hey. All right, so let's see who's with us tonight while we are waiting for Darryl to come in. Mike Lee, welcome.
Well, thank you for having me.
Hey, Darryl, thank you for joining us. How are you this afternoon, early evening?
I'm doing absolutely wonderful. Just want to make sure you can hear me clearly.
I can hear you. Can you hear me?
Definitely.
All right, we're working here. We got this going.
Exactly.
So welcome to Sunday Sessions. I'm just filling in our viewers in about who I have with us today and what we're going to be talking about.
Good.
So I'm just going to give a shout out to some of our viewers that have joined in real quick. We have Nick Bezel. Hi, Nick. How are you? Welcome. Curvaceous Tips has joined us. Attorney Tammy Allison. Hello. My friend from Howard University, my Howard University sister. We have Angel Gordon joining in, and my cousin Deborah K. Baker, always supporting me. Thank you. All right, everybody. So let me just give you a little bit of background about Mr. Scott. He received his undergraduate degree from the University of Houston, mechanical engineering. He received his JD which is his law degree, for those who don't know what JD is, from South Texas College of Law here in Houston. He has been practicing intellectual property law for the past 20 years or more?
No, not for 20 years.
I
was practicing intellectual property law for 6 years. Been a lawyer for coming on 11 years, but I've been in the IT and engineering world for 20 plus years.
So. All right. Well, thank you for clearing that up for us.
No problem.
All right. So I want to just jump right into this conversation. And for those of you who don't know, I know I have family and friends who are always asking me all kinds of legal questions that are way beyond my practice areas. So, I tried, as I was explaining before you came on, I tried to answer some basic copyright questions regarding some issues that, pop up as far as social media posts and everything. But I'm going to let the expert, subject matter expert on this subject, take it away. So can you just give us just a kind of a brief overview about what intellectual property law is and what it entails?
Sure. So there's three primary areas of law that falls under intellectual property law. Now, there are some subsidiaries of those three areas, but those three areas include patent protection, trademark protection, and copyright. Now, the other ancillary is trade secrets, which is basically kind of a mesh between IP and contract law, but the main three are patents, copyrights, and trademarks. Now, with patents, I'm sorry.
Oh, no, I was just saying, okay.
Okay, so with patents, particularly, patents are there for you to protect your invention or your idea, anything that you conceived of. Anytime that you solve a problem, you may have a patentable idea. Trademarks, on the other hand, deals with your brand. So if you have this awesome name, this awesome Facebook profile or Instagram hashtag, those things can be branded. Now, with branding, you have to have some type of service or product under it, meaning that you just simply can't just have an awesome catchphrase. You can't trade phrases. Well, I receive a lot of calls on that, and I tell them, no, you have to have some type of product or service associated with that trademark. And
Okay, so what can you just? I didn't mean to interrupt you.
sure, no problem.
As far as service is concerned, what would qualify as a service if you don't have a product?
Sure. So legal service, dentistry, any sort of difference. I guess the best way to explain it is to distinguish the two. So with products is that you have some tangible product that you sell, like Amazon or anything that you sell on Amazon. Service is when you selling you selling your what you your,
Let's clarify that.
so you kind of knew what I was about to say, but I don't want to give.
Yeah, we're here.
Yeah. So you selling your skills from here. Exactly.
Okay, those are the kind of skills we're talking about, people. Let's keep it G and PG rated, all right?
There's a market for it. Don't get me wrong, but I don't handle those.
Okay. All right, but okay, but let's just put this out there. That service, it can be. Are you saying that service can be branded? Okay.
No, not legally.
Not okay. All right.
Now, you can only, as far as business is concerned, yes. So
Okay.
there's two aspects of intellectual property law. There's the legal aspect and there's the business aspect.
Okay.
You cannot separate the two.
Right.
So we're trying to make that a point with my client.
Okay. All right. Well, thank you for clarifying. That's what that's. Okay. So as far as copyrights are concerned, we're talking about music,
Yes.
film.
Yes.
What else would go underneath that umbrella, so to speak?
So anything that you can memorialize in some type of tangible medium, meaning that you can, back in the old day when we used to make music and put on a CD or a jump drive or MP3, art that you can put on a board that you could paint, music, either music sheet, plays, anything that is artistic in nature that you can have it memorialized to something tangible, meaning that's something that can be uploaded or transferred to someone or something. So anything that falls under that creative platform. So you can name it even down to programming. So like if you have apps. So I have a lot of clients who call me about new apps they came out with, and they're thinking about they want to get a patent on it. And I let them know that you can get a patent on apps, unless of course there's exceptions, but primarily you can get copyright registration for apps because apps are considered art because it's the language. Yeah, language behind it is an art. Now for those who are creatives and create apps, they think of it as art because the language they use, the inputs, the outputs, the if-then statements, all that programming language is a method of art for those who are creative in that respect. So that will fall under copyright law as well. So books, music, sheets, plays, movies, pictures, not your profile picture. That's a whole nother different.
Okay.
I've had clients who had their image used in some other person's campaign or some person's art or things of that nature. Unfortunately, that does not fall under intellectual property law, but that falls under the misappropriation of likeness, which is a civil matter. So that falls under the civil world. So I usually direct those to my colleagues who practice it.
Practice civil law. All right. So, what about photographs? Now, I had a question about, okay, so if you use somebody's photograph, if you see somebody's photograph or just a photograph that they post on their profile and you want to use it,
Sure.
If it's a photograph that they take, is that copyrighted by the person that took it?
Well,
is it protected?
So it's kind of layered. So the copyright law states that the person who owns the flash is the owner of the art, unless there's some type of agreement. So if I take a picture of you, I own your picture just by the fact that I own the camera. Now, there's some type of agreement or arrangement, then yes, that can be assigned over to you. Now, as for does it fall under IP law, it doesn't by default. You would have to register that particular image with the Copyright Office in order to get protection. However, as many selfies that we all take, if you look through someone's phone, you'll probably see 100 different photos, but you only see one posted.
Right.
You ideally have to submit all those photos, but that's not the wisest thing to do. So what I would tell people is to file a civil claim under the misappropriation of a likeness, and you can get civil recourse for any type of damages for your images being used.
Okay. All right. Well, let's go to music. I've had a question about this. People, I've seen on Facebook and Instagram about people putting this disclaimer up about, I don't own the rights to this music.
Yeah, we know that.
And duh, I mean, unless you're
Yeah.
following like the artist and they happen to post their music up and
Sure.
whatever.
Sure.
But typically, unless you have a license to use music, is that a copyright infringement?
So there's one thing about law, we always have that it depends answer, right?
Yep.
Black and white. So it's kind of layers, particularly with music or anything that falls under copyright law. So the quick answer is that if a person were to use someone else's music, like on Instagram, and just have it playing in the background, then by that alone, then no, you're not infringing.
Okay.
Where it becomes infringement is if there is a causal connection between your use of that music and some type of profiting that you're doing. So if you're using that music to bring in traffic for your business, then yes, you may have the potential of copyright infringement. Now, there are exceptions to that, which falls under the Fair Use Act, where you are using someone's copyrighted material for parody purposes, for not description, but a commentary, or if you are doing, nonprofit purposes, things of that nature, then anything that can kind of push yourself away from profiting off of someone else's material will have you fall under what they call the Fair Use Act. Now, just to let folks know, you just can't go out there and argue, hey, I'm using this fairly under the Fair Use Act. No, it doesn't work like that. That is based on a judge assessment if you actually fall under the Fair Use Act. And by that time, if a judge is looking at your case, it's probably a little too late. So I tell folks, if they are concerned about copyright infringement, by the mere fact that you're calling me lets me know that you do have some concerns and that you should acquiesce to that and just not use it, right?
Right.
Use something else. Try to get around it, because the thing is that it will cost you more on litigation than it is just to do something different. So that's what I try to steer my clients to do. Is just don't even poke that hornet's nest.
Right. So, I mean, I've watched a couple of IG lives where they were playing music in the background and they kept getting kicked off of IG.
Yeah.
And is that the reason? Because IG is afraid of them somehow getting pulled into this? Like, oh, okay.
Yes. So Instagram and Facebook, even though I have my little issues with them, with with my clients, there's a so when we sign up for Facebook or Instagram or post a video on YouTube, we give a license to those organizations to use our material the way they see fit. Now, it's not an exclusive license, but they can use our information. They can use your photos, they can use this video, they can use any other thing for their purpose. But that's just the benefit of having a free access to Instagram, Facebook, YouTube, things of that nature. However, when it comes to, how can I phrase this? So with Instagram, what their position is that the people who are at most risk, or the people who have the most litigious personality, will be your artists. So it is what they take is the risk averse route. Is that okay? Many of our users using this music, even though we know that it may not fall under copyright infringement, we prefer that we just shut it down, because we just don't even want to deal with it. So it's not that you are infringing; they just making a risk assessment just not to open that up. So yes, there's times where Instagram will kick you off, and you should not be mad. Just make up your own music. Have someone. I don't know.
or don't play any at all. I mean, that kind of will solve the problem as well.
Exactly. So yeah, we definitely have to be careful, especially in the digital world, because information can be passed so quickly, and there's no way that we can pull it back. Even with websites, like for example, when people go out there and start snatching clip art or images off other people's website and put it on their website, you're actually placing yourself in a position to be for a lawsuit to be filed against you. So I tell people, if you get any type of clip art, images, things of that nature, make sure it's your original piece, or it's something that you paid for, because now there's technology out there where they can actually crawl your website, or they can crawl every website to find that image, and then they just start blasting out cease and demand letters.
Really?
Mm-hmm.
So have you experienced that? I didn't even know that about clip art.
Yes. So anyone who has a website, please do not snatch anyone else's art. Don't do it. Just take it down now. Right? So, right now they're actually crawling every website out there. And if they find yours, it's snatched. Even if they crawl today and you take it off tomorrow, you've already infringed because they captured that date in which you had the image up there. All right. So you make sure you out as quickly as possible. So yeah, it's an interesting area of law. It's boring, it's transactional, but it becomes interesting.
Well, I mean, I would imagine that it's become more interesting in the age of social media, like you said, where everybody is kind of like taking bits and pieces just from everybody's page and reposting, because that's what you do on Instagram. You see, you repost.
Yes. Now here's the thing though. If you're reposting, so I don't think there's any case law on this yet, but I'm sure there will be, and maybe I shouldn't speak about it because they may create it, is that, there's maybe a person out there who created this awesome meme that just blows up, right? And everyone's reposting it. Ideally, we all have common law copyright protection for anything that we create. So like the art that I create is copyright protected without it being registered. The only difference is that in order for me to bring a lawsuit, I have to actually register it with the government. And then once I register it, I can get damages, but it's less damages. So the key is that if I want to make sure that my art that I create is protected, once I create it, I publish it and then file it. I should not wait until it becomes infringed, then try to file it, because you're missing a lot of money that way. So
if I were just to paint something and take a picture of it and post it up on Instagram, it's not protected. Anybody can use it, basically.
No, it is protected. By default, it is protected. The only thing is that you, as an individual, you have to register that infringed art.
Oh, gotcha.
And then you can bring a lawsuit. So if you think back to, there was a lawsuit that came up with Carlton, the Carlton bands, right?
Right.
Right. So he was trying to, and there's this game, I can't think of that game that a lot of those young kids play, where Fortnite. Yes, Fortnite. So they was using a lot of those avatars and mocking or imitating the Carlton dance. So Alfonso Ribeiro, he filed a lawsuit against them, but in order to proceed with the lawsuit, he had to register the dance. Unfortunately, dances, like short dances, are not copyright registrable. You actually have to have like a whole scene, I guess you could say. So like a ballet, like a whole recital would be copyright registrable, but not just like a football touchdown.
Okay.
Yeah, that you can't register.
You can't do that.
So he had to dismiss that case, and unfortunately, everyone is using the Carlton dance and not making any money.
And it is what it is.
It's what it is. So, but he may file a civil suit under the misappropriation of likeness. So hopefully his lawyers did take that route. So, but I doubt it.
So we have a question from Roxanne Rizzi that says IG DJs play more than the allowed 2 minutes of music all the time. So let's just take, for example, D Nice when he was having his club quarantine, right? How is he allowed to play all of this music that he plays and not get kicked off of IG?
Lobbyist.
Oh.
So there is an exception for DJs. So if you're a DJ, and you can make the argument that you're a DJ, then yes, you could play anyone's music all the time. The only exception is that you have to actually have ownership of any music that you play. So you have to buy each digital download or whatever music he plays. So DJ D Nice, he has all those records that he paid for. So he can play them all day and he can make money off of it, but he's a DJ. So unless everyone wants to become a DJ and that's the only source of income that you're going to have, then yes, you can do it then, but it's not worth it. So, but yeah, they make exceptions for DJs.
Wow, that's pretty interesting.
So he can do it all day long.
All right, so I kind of want to just stay on the music realm, so to speak. So if you were just bored one day and just sitting there creating some beats, right? And you just happened to, I was like, okay, just see what type of feel you get for it on social media. If somebody were to pick up that beat and just start reusing it, and you didn't register it, you didn't do anything with it, what happens?
You just got to sit back and get mad because there's really nothing you can
There's nothing you can do. And that's why it's so important.
Yes.
That if you're trying to get into the industry, then you're making music, don't put it out there for other people to hear.
Exactly.
before you take the proper legal steps to protect it.
Well, you can just keep the window short, between you and here. Then registering a copyright is so inexpensive, so it would be good for you to quickly post it and file at the same time, so you can have a published date and a filing date are close in proximity. Because
Okay.
the likelihood of someone stealing it will happen after the date that you registered it, or at least the date that you filed it. So you have the better chance of getting more of a payout once you sue someone for copyright infringement. So yeah, there's a with IP law. So yeah, let me give you the public disclosure rules for each area of law, because sometimes
Yes.
it can be a little challenging, because people tell me, well, I have this trademark, this brand, and I don't want to show anybody, or I have this art or this music, I don't want nobody to listen to it. I have this patent idea, I will kill you if someone find out about it. So
Right.
so in the patent world and for inventions, yes, you do not want to disclose your invention to anyone. Not your mama and them, not your sister and them, none of those folks, right? As much as
Okay.
you can, right? Not until you actually follow it. Now, they give you a little bit of a leeway in that area. So for example, if I decide to go out and hit the market to see if this invention is even viable and it's been published, meaning that the public has seen my idea, then I have a year from that date of published to actually file it as a patent. If you miss that date, you're done, right? It's over with. Now, I usually tell people at that juncture that if you're trying to do a market study, you want to file what they call the provisional application, which is very, very, very inexpensive. You get it on file and you have a filing date, and you can do whatever you want to do within a year. And then within a year, you can file a subsequent patent application from that invention. Now,
Okay.
with trademarks, on the other hand, yes, everyone needs to know what your brand is. Publish it. You come up with it, you tell everybody that idea. Because once you tell that person your brand, then at least you can get some feedback on the marketability of your brand, right? And then
Okay.
you can also find out if someone else is using your brand. And then you don't want to get so invested in that brand where 10 years later you realize that someone registered their brand a year before you and you got to shut it all down. Same way with copyrights. You want to keep the window short, but you definitely want to get it published before you actually register it. So, but just keep it very short, almost within a day or two or within the same day. So yeah, so just to recap, trademarks and copyrights is okay to publish. Patents, do not tell anyone at all.
No, no, no.
And
Okay.
even with me, I don't even listen to a person's idea unless it's under some type of non-disclosure or some type of engagement letter.
Well, that was going to be my next question. I mean, and I always stress NDAs. I mean, especially, if you're talking about ideas, works, productions that you want to do, and you're talking to somebody else about it, make sure that they sign an NDA.
Yes, definitely. So, but yeah, people are actually moving in that direction where they're more conscious about protecting their ideas. So I'm excited about that. So.
Yeah, I mean, like I said, I mean, I know that, during the pandemic, we were all kind of locked in, and, I've talked to various people, including myself, that had their creative juices flowing and, started, just moving in all types of creative directions. And, I know I reached out to you about doing some, copyright trademark work for myself. So.
And the reason is that I tell some of my friends and colleagues that this has been the most creative 6 months that I've seen. And the reason is that, the most creative people are those who are institutionalized or those who are in jail, right? Because they have all the time in the world to do whatever, think about ways of, accomplishing this or that or whatever. So
Right.
Us as citizens, we have been virtually locked up because we can't go anywhere, or we have been restricted from certain areas. So we have time to just think. So
Right.
I have been over inundated by a lot of creative ideas, a lot of concept brands and things of that nature. So it's been interesting to see. We're very creative people. I'll tell you that.
Yeah, absolutely. And I mean, I know that you're an artist, and I hopefully you might be able to show us a piece of your work before we end here, because I'm just like, I'm just amazed. Like, you see people, and you just think that, okay, they're just a lawyer or a doctor or whatever, but then you see them posting up, drawings and art. I'm like, wow, I would never have known.
Well, sure, I could do that. I have a few pieces still left here because I usually give them away.
You don't sell them?
No. So I have the same reaction all the time. So my art for me is therapeutic. right? I just use it just to whatever idea that I have. It's more creation. So I
Right.
guess it's the engineering side or whatever. So it's like I have this idea, I create it, I look at it, I get bored, give it away, and then so I have I have four pieces up there. I think I still have, and I'm actually gonna start working on one tonight.
Wow,
So,
that's good stuff.
so
I mean, I kind of like dibble and dabble in that myself, but
good, good,
one
good,
day I'll show.
good.
All right, so getting back to our topic. So how long do copyrights, trademarks? I mean, is there a do they expire after a certain amount of time?
Yes. So with patents, for example, it's 20 years from the filing date. So and it takes at minimum 2 years for a patent to prosecute. So you'll have 18 years at the most for patent protection, and then after that, everyone can use it. The for design patents, it's 10 years. For trademarks, so with trademarks, it's continuing. So you can have those as long as you want to have them, but you have to prove to the government every 10 years that you're still using that brand under the service or products that you initially filed it under. So you have to just renew it every 10 years.
Okay.
Rights, I can remember, and don't quote me on this, I think it's like the life of the artist plus 70 years, maybe 75 years. So it's somewhere in that ballpark. So copyright, long time. And you can actually assign those. So, here's the other thing too. I tell people, think of your intellectual property law like property, like your home or your car or
Okay.
whatever, right? You can assign that over to someone. You can will it away. So I've had a lot of calls from people who practice probate law or wills and trusts, where I
Right.
have a person who passed away who owns some type of art,
Uh-huh.
whether music or an invention or idea. I've guided them on how to write language in their will so that that instrument, intellectual property, can be willed to an heir. So think about it like that.
Wow.
Anything's just floating in space. It's something that has value. So even with trademarks, I tell my clients to assign your trademark to your company, not necessarily yourself. I mean, if you don't have a company, fine, but you definitely want to assign your trademark to your company because now you're adding value to your company. So if your company is sold one day, you can say, I have a portfolio of art, whether it be your inventions or whether it be your brand or whether it be your copyright material.
Okay.
All that to your company. So if you decide to sell your company, you can value your company at a higher rate if you would not have had it assigned to your company. So,
Okay. So, do you handle a lot of copyright infringement cases from like artists? So, I know that there have been a couple in the media. I mean, over the past few years, like, oh yeah, somebody, took my beat or sampled my beat, or you know the drill.
yeah, it's so because of I have a team now that will handle my litigation for me. And the reason why I am now have to shy away from the litigation aspect of it is because I'm going to be an arbitrator soon. As a matter of fact, next month I'm training to be an IP arbitrator, and then
Okay.
I'm an associate judge with the city of Houston. So I have 60% of my work deals with the judicial realm, so there may become a conflict. And with me prosecuting copyright or trademarks or patents, I can become, you probably know this as a lawyer, that I can potentially become a fact witness on it
Right.
that I'm litigating. So I try not to litigate cases in which I was the attorney on it.
Okay.
I mean, there's been times where I'll get pulled into it and I can work my way around it, but it's much more better to have another attorney on the team who handle my litigation.
Litigation.
Yeah. So I know how to handle it. I have to make sure I create that protective barrier between my client and their art, so that there's no issues on the other side.
Well, I mean that makes sense because, like you said, you don't want to become a fact witness. That's not good. That's not good, everybody.
Yeah, because they're real short.
All right. Well, tell us what's the most interesting copyright issue that you have dealt with.
So without going into many details.
Yeah. No, just generally.
Okay. So here's one that. So let me do it like this. Instead of telling you about the particular facts, I'll just give a warning about that or revolves around the facts.
There you go. I mean, like I said, this is to provide information to our viewers about what not to do.
So, and I have one for trademarks. I'm gonna do one for copyright. I'm gonna let you know one for.
Okay.
So, I had a situation. So there's this rule out there. There's a federal rule called the Anti-Cyber Squatting Consumer Protection Act. That's long. So,
Yes.
so basically, what that is, it's a law that allows a trademark owner um, to protect their domain. So, like if I have, for example, if I have Nike, Nike is my brand, right? But
Okay.
after I brand Nike, I forgot to register Nike.com, Nike.us, Nike.org, or Nike Shoes, or NikeShirts.com, or whatever. Someone
Right.
goes out there and buys all those domains, right? And then they decide to hold them and wait for my value of my organization that goes up. And then
Yep.
I start to say, oh man, I need a website. And I go and see that those domains have been purchased, and you see that the domains, instead of it being $11, is $1,000, right? They have
Right.
rules out there that says that they would have to give that up. So I was in a, there was a case where, and I won't say which side I was on, where
Okay.
the individual had to give up their domains, give it all up. So
Wow.
they had to give it all up because they registered a domain, and they didn't know, they didn't do it intentionally,
Okay.
but because the organization that was being infringed on had a lot of money, a lot of money. As a matter of fact, they was a nationally known bank, so I
Oh.
didn't want to deal with that. So we they I'm just telling you, yeah. So we had to get rid of those domains. So I basically just told you which side of the aisle I was on. So
Okay, so if you're thinking about starting a business, starting a brand, doing whatever, it's really important that you go out and secure your domain as soon as you,
yes,
right?
yes. So secure your domain, secure your business name, and then secure the trademark. So typically, what I try to do with my clients, especially in the trademark world, is that before they get too invested in a brand name, one of the things I tell them is just pause, hold up a minute, wait a second. Let's first see who's out there that's using it, right? Let's see,
Right.
not only using it locally, but who's using it internationally, who's using it nationally, who's using it on social media. What happens if you type that word into Google, what pops up? What are your competing search terms? So I also do a digital marketing analysis to determine whether or not that is even a viable mark. Now, once you do that, I do that. Then I tell them to look to see if the business name is available. How many other people have the same business name? Or, see if the domain is available. Is it .com available? Is it .org available? How many other people are using that same domain name? And then,
Right.
lastly, how creative is your mark? One of the things I tell clients is not to use a descriptive name for your mark. So, like if I'm selling motorcycles, I'm not going to trademark Darryl Scott's Motorcycle Shop, right? Because
Okay.
anytime someone types in motorcycle or Darryl Scott, many people pop up, right? Or
Right.
that variation will pop up. So it'll be a lot more challenging for my client to be able to distinguish himself in the marketing world, because we no longer have the billboard marketing. We don't have the newspaper marketing. We don't have the magazine marketing the way we used to do it back
Right.
20 years ago. Now it's all Instagram marketing, Facebook marketing, Google ads, Bing ads, whatever. So you have to make sure that you can compete against others who have the same searchable terms within your brand name. So let's think of
Okay.
a brand name that's just so unique that if you type it in Google, that nothing pops up.
Nothing else pops up.
Exactly. So because once you register it, you get at the top of Google search engine just by default, and
Ah.
that's money. I mean, because it costs a lot to register, or at least to get yourself at the top of the search engine for Google. So I try to just be very strategic about how we register brand names for our clients. So I've broken a few hearts.
I'm sure.
I've actually said, nah,
They can't do it.
don't, nah.
So what about substantially similar names? I mean, nope. Anything that sounds something like it along those lines, that's just
It's not. So the thing is that it's not worth it, because let's just say, for example, the government says, great, you can use it, it's okay. But then that does not stop the person who has a similar sounding name to still file a lawsuit against you. And
Okay.
you're continually fighting that battle, right, as your business is growing. And then there's a story I have about not my client, but it was a story of a client. It was a couple in California, and they owned a bicycle shop.
Okay.
Been in the business for about 15 years, doing well, a mom and pop store, right?
Right.
They didn't protect their brand. And all of a sudden, they got a cease and desist letter saying you need to shut all this stuff down, right? Now, of course, they went to a lawyer. The lawyer let them know, like, yes, we don't have a dog in this fight. You might need to start rebranding. So rebranding in the middle of your business growing is the most detrimental thing that you can do. Because
Okay.
what happens is that people's psyche start thinking that either there's some management changes, or there may be some bankruptcy or something that's going wrong with the company. So we're not going to patron them anymore. So that company out in California, they folded simply because they just couldn't afford the rebranding. So I tell
Wow.
you don't want to be in a position where you've invested so much and you got to give up your domain, your business name, your business card, your paraphernalia, your art, everything associated with your mark to someone else for them to use, and then you have to start from scratch. It's the most challenging thing, and I've seen some people go through that, and it's not good.
It's not fun. So listen up, followers, viewers, you guys, please, please, please reach out to an intellectual property attorney in your area. Or let me ask you this, you have clients all over the country. So how does that work?
So it's federal practice. So
okay.
This is really the first time, like I saw a few clients pop in on here. This is probably the first time they actually seen me before, talking live.
I have clients like that too. I mean, reputation and, word of mouth is beautiful marketing.
So they're probably wondering like, oh, damn, that's what he looked like. He sounds a little different on the phone, right? At least I could act like I sound like I'm 80 years old, but
stop it.
Like I'm 20. So, but yeah, so a lot of my clients are outside of Texas.
Okay.
I have international clients as well. So I have had some in Australia, China, Canada, Mexico. So I can file anywhere. Now, Of course, I can't file myself in those countries, but I've established enough relationship with attorneys out there to where they can facilitate the filing for me.
Okay.
With patents, with trademarks, one of the questions that I ask is that do you potentially want to file internationally? It's very expensive, but if you see your business growing internationally, there's some deadline dates that we must meet in order to capture the filing date. So like with patents, if you want to have international protection, you have to file within a year of the original filing.
Okay.
Trademark is within 6 months. Copyright, they don't care, right? Because it's your art, right? But those two, yes, you have to file within a certain time to get international protection for your idea or brand.
Okay, so if you were to trademark or copyright something in the United States, mm-hmm. It doesn't automatically protect you worldwide.
Nope, just U.S. only. That's it. If you want to get let me see, protection in Mexico, you have to file in Mexico. If you want to get protection in Brazil, you have to file there. So you have to file individually in each country.
In each country.
Now, there's mechanisms that can help facilitate that on an administrative level. But as far as clients are concerned, you're still going to pay those individual filing costs, attorney's fees, maintenance fees. They can become very expensive. So clients who are looking to go international, one of the things I tell them before you start just naming all these different countries is do a market study, do a market analysis, determine whether or not someone's going to potentially infringe on your brand in India or China or Russia. Like if you're selling refrigerators or air conditioning units, probably certain parts of Russia, they probably wouldn't care, right? It gets cold. So I wouldn't even worry about filing there. So just think about those things first before we start moving forward. So that's some of the services that I try to provide to my clients is to have a business strategy. So 80% of our conversation is business strategy versus the legal strategy. Because that's key. That's key.
Very, very important. Mm-hmm. All right. So just real quick, what is the time frame? So that if you want to file, your application for copyright or trademark, typically how long does that process take from start to finish typically?
So break it up in two parts. So with copyright, with me one-on-one with a client, it'll take me a day to file it. Not a full day, but I'll get it, I'll file it. And of course, there's the consultation, there's the discussion that's giving me the material, all the information I need. I get it filed, we're good. Once it's filed with the Copyright Office, anywhere from 4 to 6 months before you get a registration number from them. Trademarks, same difference. Get the information, we consult, I do a viability analysis, let the client know, like, no, this is not going to work. You need to change it. We need to start all over again. So if everything is good, once it's filed, trademarks take anywhere from 8 months to a year, depending on the availability of the examiner and how quick they respond, and also how quick I respond, which means how quick the client responds to me. Right. You already know
that's
that.
That's always a factor.
Exactly. So with patents, the process for them, depending on the technology. So when I was doing work for an oil company or filing a patent application for an oil company, those patents took at minimum 3 years just before
Wow.
an examiner picked them up. Now,
Okay.
when I'm dealing with your mom and pop inventions, we're looking before COVID.
Well, yeah.
Yeah, it
Let's
was.
qualify these
Yeah,
answers. I'm sorry.
yeah. All this is before COVID, so all
Okay.
this is subject to change. So with the patents, it was before we even received a notice from the government, 18 months, all right, and potentially 2 years before we get a notice of allowance with patents. So I tell my clients, this is the strategy we need to take. So if you're trying to hit the market real quick, let's follow provisional. Let's see what happens. Let's not invest in the patent unless you can see some momentum in the product.
Okay.
And then there's been cases where I just tell folks just to go straight to the market. So I give an analogy. So when I was in my office, and I may not ever go back to my office because I work at home.
I know, especially when, like you said, you can practice, you have clients all over the country. So it's not like you're going to be seeing them in person anyway. So,
No.
and ditto on that, but go ahead.
So, I just lost my train of thought. Okay, hold on. I lost my train of thought. What was I talking about?
This is a candid conversation. So,
Pretty much.
we're allowed to, just go off topic here and there.
I totally forgot what I was about to say. It was very important.
Oh,
It's a
I'm
Sunday.
sorry. No. You were saying that, the patent office was backed up. Once you filed, you may never go back, to your office. And I don't know.
Oh, yeah, I totally lost. So,
That's all right.
let me just. So let me just get some tips. Let me get some tips for.
Yeah, and then we're gonna see if anybody has any questions, and we'll do some shout outs.
No, yes. So I can answer. So my tips for patents. A lot of times people don't think they have a patentable idea. Anytime that you solve a problem, right, to some extent, solve a problem that may be potential for a patent idea. So give me a buzz. I don't charge. I'll hear it out. Now I remember. Okay, pause.
Okay.
Rewind the tape. I remember what I was about to talk about. So, there's been a situation where if a client comes to me with invention or an idea or some type of new product they want to go to the market with, if I know instinctively that it's something that's not patentable, I'll tell them to go straight to the market. And I use this analogy. So in my drawer, it was given by another lawyer of mine, shout out to Marty if she's watching, is a fake Gucci watch. Right. And I pull out the fake Gucci watch and I put it on the table and I show the client and I ask the client, can you distinguish this watch between a real Gucci watch? And they say no. And I say, exactly. So Gucci understands that if you go on Harwin, for those who live in Houston, understand what Harwin means. I started buying all these particular products.
Knock off street.
Yeah, right. So they have these particular purses, watches, or whatever that look like Burberry or Prada or, Gucci. So I tell them is that Gucci understands that they have to invest more in their marketing than they are in their litigation and prevention because they already know they're going to get knockoffs. And it's not worth them trying to go after each and every single person, but just focus on their branding. Because if I show you a fake Gucci watch and a real Gucci watch, they both work. They both tell time. They both have a battery in it. They both look alike. But consumers, for whatever reason, I'm not like that, except for Apple products, is that they won't buy the expensive Gucci product versus the $40 fake Gucci because the brand behind it. So I tell my clients, if you have something that you love and I know it's not patentable, brand it. Let's go trademark. Let's market. Let's be the first in the market so that if someone comes behind you and try to imitate it, they're going to still go to your product because you were the first to the market.
Okay.
And you're going to have value behind your name. And we just keep pushing it. Then once your brand has grown, then you can start selling other products. And then you could potentially come out with an invention or a product that could fall under that brand name. So that's branding and business strategy is very, very important in this world for IP lawyers, or at least it should be.
Absolutely. So I have a question real quick. So are you protected at the moment of filing, even though you don't get a registration number until months down the road? Nope, not until you get that registration number.
No, it's just like home ownership. So in the process, you have the contract signed, and they're going to go through that escrow period or whatever that closing period, that 30 days.
Right.
So think of that 30 days as 18 months. So
Okay.
it's yours, but it's not, right? Until you actually close, you got the keys and you got the registration number. So, but what you can do is you can put patent pending. So you place individuals on notice that if you decide to go out there and start building this product,
Right.
knowing it's pending, and if I get registration, guess what? I can knock on your door with a U-Haul and bring it all home to me. Thank you for starting in advance for me. So you can shut them down, you can move forward. But no, unfortunately, until it's registered, yeah, you don't have any protection.
Okay.
Now, trademarks, on the other hand, you have common law protection to some extent. So you'll see a lot of organizations will put TM or SM next, a superscript next to their brand name.
Uh-huh.
What that means is that it's not registered as a trademark. They're just putting people on notice that this is my brand, and
Ah.
infringe on it. I'm still gonna knock on the door, but I don't have enough teeth. I don't have ownership of it. I don't have federal ownership over it.
Federal ownership.
I have local ownership over it, but not federal.
So if you just start putting TM behind whatever your name is, you're protected. Okay.
Just within your jurisdiction.
Within and with jurisdiction means within your state.
No, it can be just as limited as your
city.
It could be limited to that too. Like, so Houston is very large. So if
Right.
there's a Katy organization with the same name that's have TM, and then you have Channelview or Baytown. Well, Channelview is better because that's in kind of Houston. Then the judge can actually say, well, you're going to cover the east side, and the other person is going to cover the west side.
Right.
You can't cross over anyway. And it become very, very, very narrow. So.
Okay.
So that's why I tell people to go ahead and get federally registered.
And I just have one more question on the jurisdictional issue. So, when I do corporation searches for my law practice through the Secretary of State, there's an option to apply for trademark. Now, or is it just a trademark search? What is that?
No. So state trademarks are just state registration.
Okay, thank you.
You have rights in that state.
Okay.
Now, if somewhere in Louisiana or some other state trademarks the same thing, then in their state, then they have protection in that state.
Okay.
But if you register with the USPTO, then you have federal protection, all states. So
gotcha.
Federal protection.
Okay.
So let me do this because I know there's some what's that, Patti LaBelle and everybody else who's supposed
to. So let's get to a couple questions, and then I want to see some art. But you can get to the art. So we have a question from Boho, Black Girl. What about an established brand applies for a utility patent?
Okay, I'll say the question again because.
What about an established brand applies for a utility patent?
Yeah, I think there's two different languages being used under. So when I have brand, I'm hearing trademark. Utility patents are just patents that have some type of utility nature to them. So there's like chemical patents, there's mechanical patents, there's design patents. So ask them to see if they can refrain. Should you do both federal and state trademark? No.
Yeah, that's another question. Yeah.
No. Just do federal if you can. One is cheaper, and two, once you do federal, you already automatically have protection.
You're protected throughout the country. Absolutely.
Yes. Exactly.
And I have one more question. Let's see. Angela Gordon says, "What if they don't register the company name first?" Mm-hmm. And then she said, on the subject of trademark, if there is someone who may have the same name as yours in the same business, let's see. I don't know what happened to the rest of the question, but anyway, okay.
Oh, I can answer that question for you. So yeah, if your business name is not available, don't even try to trademark. So the goal is to try to make sure that your domain name, the business name, and the trademark name are available before you even buy your business cards or start selling or providing any type of service. You want to make sure all that's available, because the one thing that you don't want to do is have, let's just say that you was Uber.com, and all of a sudden Uber.com is taken.
Right.
You have some other name like sharearide.com, right?
Yeah.
So you just can't combine those two, right, under one umbrella, and it makes it much challenging to brand. So.
Okay. Thank you.
No problem.
All right. And Darryl is going to show us some of his beautiful artwork. Hi, Ashley. Thank you so much. Ashley to me.
So this is one of my pieces here.
Oh, wow.
So just to give you a little point of reference, this is how big I am compared to this, right? So let me flip it back around. So this is my little baby sister. All right.
That is beautiful.
So I did go to the hood market to get some of these dreads. So this is all done. So this is all done in pencil here in this area there.
Wow.
So got it real detailed to where you go in the eyes, you can see like it's glaring. So of course,
Yeah.
I had to get some fake earrings and then had to do this little bonnet thing.
That is beautiful. So that's called like a multimedia type of work. That is
Yes.
beautiful.
I was bored with that one. And then
I told you he's talented, you guys. I
so
see his post and I'm like, oh my gosh. Wow.
So this one I try to do myself. So I have this wall that goes upstairs, and I don't have any. I have pictures of me and my siblings, but I figured like let me just do my own art of my family.
Right.
Here, so here is a picture of me, and the thing that's on here that's 3D is the
earrings,
which I have my ears pierced. I sometimes did as a kid,
okay.
And then my glasses. I did this with
wow,
cord and a coat hanger. So,
are you serious?
Yeah, and then of course I had to represent, so I got the little chain. So it looks
wow,
fall down these steps, but so
amazing.
And then my brother, he got mad at me because he got gray in his beard, so I had to put gray. So I did this picture here of him, and his beard is actually 3D.
Wow.
So what I did with this one is this was my niece's fur jacket. Okay. So I cut it up and just kind of super glued it all around and made a beard out of it. So
wow.
Yeah.
You are, that is amazing. Beautiful, beautiful work. I mean, like I am like just, I'm into art,
I guess so.
And that's what I saw, you guys.
Yeah, this one is
you posted that on Instagram and Facebook. I saw that. I'm like, oh no, we have to mention this during our discussion.
So yeah, this one. So what I'm trying to do is lately now just kind of have message art. So like when you look at this, someone should at least be able to say, carrying a heavy heart.
Right.
Right. So that's kind of the message with that one. So the next one I'm gonna do, and since I'm gonna say it out loud, that means I have to do it. Is trying to hold on the time. So. So and here is a colleague of mine. She gonna be mad if she's seeing this, but whatever. So this is basically this is COVID dating. Right?
Oh, that's been interesting. I'm just gonna leave that alone.
Yeah, we're gonna leave that alone. So let me flip it around so I want to show all my house to everyone.
Yeah. Oh, thank you for sharing. You are, like I said, you are so talented.
Well, thank you.
All right, you're welcome, sir. So, all right, you guys, we are about to wrap up this discussion. If you have any questions, Darryl, please give us your information, office, IG, Facebook, so that our viewers can get in touch with you.
All right, so my office line is 832-446-3337. Of course, you can just Google search me, Darryl Scott Attorney, and I'll pop up. You can go to ineedpatentprotection.com to find my website. You can go to @Darryl Scott on all my social media handles. Now, I'm not big into social media, so you won't see me making all kinds of posts, but I do go to social media for any type of messages or questions that people have for me. So you can talk to me anytime. I'm not doing anything anyway. I'm just sitting here drawing, drinking a little bit, right? So,
hey, that's what COVID has brought. All right. Okay. Well, let's just give a few more shout outs to our viewers. Miss Dawn Florio, thank you so much. I'm a little tongue tied, and Dawn is going to be my guest for next week. I had Dawn. She is a criminal defense entertainment attorney, celebrity entertainment attorney up in New York City. Amazing. My sister in the law. So looking forward to chatting it up with her again. I Push Radio. Boho Black Girl real quick says, do you have rights and clearances?
Do I handle rights and clearances? I haven't, but I understand it. So if it needs to be done, I can take care of it.
Okay. All right, then. Well, everyone, let me just, BC Reed, hello, Benita. I saw Ali, hello, Making Moves with Michelle, hello. My sister, my sister teammate, I am Aurora G. I think that's Jamie Foster Brown on there. Hello, Real Sister 2.0. Cake Lady, hello. My niece, Reagan, hello. Thank you for joining in, my love. D Star. I am Rozzy. So if I didn't get to you, SuperNat813 joined in. So if I didn't get to you, I'm so sorry. But I just want to thank you guys for joining in this evening. I hope this discussion was informative for you. And I want to thank our guest for this evening, Mr. Darryl E. Scott. Thank you so much, sir, for sharing your knowledge and expertise with this and your art with us this evening. Please feel free to come back anytime.
Yes. Yes, thank you for having me, and thank you for creating this platform that you're going to brand soon.
So. We had that discussion earlier today. So, like I said, I have some news that's going to be coming across, my pages hopefully the next few days about expanding my viewership. So, yes, I'm going to have to do that. So. Thank you for reminding me. Monique the Heiress joined in. All right, guys, we are just almost out of time. I hope you enjoyed our discussion today. Please stay tuned for our next Sunday session. I'm going to be putting up a schedule, for my upcoming sessions for the next few weeks also, so you guys can just get a feel of what we're trying to do. Like I said, I'm Janine Hovell-Cox with It's All Legal. We talk about, all areas of life and law that always seem to collide into one another. So, Darryl, thank you again. We will be in touch this week.
And go Patty LaBelle.
Oh, that's what I'm saying. Go Patty. Yeah. So I usually have this at 7, but I had to move it up in honor of, Miss Patty LaBelle and Glass Night, because I want to listen to that. So
we're not important till they get in trouble.
Yeah, exactly. Which we hope they do not.
Exactly.
All right, sir. Well, again, thank you so much. Please continue to stay safe, and I will be giving you a call this week.
Sounds good. Look forward.
All right, everybody, please continue to stay safe and have a lovely rest of the evening, and we'll check in with you guys next week. Bye.
Bye-bye.